argument in our cause number CACV 20-0122 Lane versus Core. Before we begin, just a couple of housekeeping matters. This is being recorded, but because of the way we're doing this, I'm going to ask that to make sure that everyone is on mute who is watching the argument. Mr. Abney, Ms. Freeman, if you're not speaking, if you could mute your mics, that way we get less feedback and we're able to hear. I didn't make that announcement in the last argument and it got problematic. I live in downtown Phoenix, and so if you hear large trucks going by, I'm not being run over. That's just where I live. And I apologize for that. The building is closed, so I would normally do this in my office. With that, I will alert you that we have conferenced your case this morning at conference. We appreciate your participating with us this morning based on the building being closed via Zoom or whatever it is we're talking about here. And if you would please identify yourself before you begin your presentation, I would appreciate it. And Mr. Abney, with that short introduction, you may begin.
Thank you, Your Honor. May it please the court. First of all, I guess I should check. Can you hear me okay?
Yes.
Okay, great. I briefed as well as I could the issues concerning the cumulative causation testimony and the one expert per rule standard. I can certainly am happy to entertain questions about that, but as I say, I think I briefed that fairly well. The issues that may be of greatest importance across the state concerned intervening superseding cause, the suicide rule, and the designation of a deceased person as a non-party at fault. And that may seem odd to those who are not familiar with the tort rules or don't come across this very often, although in many of my cases, defense lawyers designate the decedent as a non-party at fault. In accident cases and in a couple of suicide cases I've been involved with. And that makes sense. There's no system, there's no provision in our comparative fault regime for allocating fault to somebody unless they are a party or unless they are a properly and timely designated non-party at fault.
Mr. Abney, I apologize for interrupting, but I'm wondering, is this really the case for us to be addressing these issues? As far as I can tell, the verdict here was a general defense verdict. There were no special interrogatories to the jury. As far as we know from this record, the jury could have concluded that the plaintiffs simply failed on their burden to show that the defendants fell below the standard of care. And so while I recognize that the issues you want to raise, particularly the intervening cause / suicide body of case law, is an interesting one and perhaps is due to be closely examined again. I'm just concerned that this is not the case to do that.
Well, as they say, this is the only case I've got. And the problem is the intervening cause instruction that was given specified as an intervening cause that supersedes the defendant's liability. And it said, if you find that Ms. Lane's death is a result of her suicide, then that will, and none of the traditional exceptions apply, then you can find that supersedes the defendant's liability. When you start telling the jury those sorts of things, they can see, well, if she did commit a suicide, well, that's the end of it. We don't need to talk about whether people contributed to causing the suicide. The suicide rule, the traditional formulation, has some very odd doors you can go through to get away from it. One of them is that if the victim did not realize what the victim was doing or the certainty of harm. And the other was whether the defendants had made it impossible for her to resist an impulse to commit suicide. And those were mentioned in the intervening cause instruction.
The other piece of this, Mr. Abney, I should add, is that even were we inclined to go down that road, we're a court of intermediate appellate jurisdiction, and the Supreme Court has spoken on this issue. We really can't tell them they're wrong.
Well, they have not spoken on the issue in the context of intervening superseding cause and in the context of non-party at fault. They haven't really grappled with what our full adoption of comparative fault has done to our system of tort law. And what it has done is now puts onto the jury the obligation in every case to determine all and allocate fault to all the parties and properly designated non-parties who had a hand in causing the harm. And if you don't designate a suicide victim as a non-party, the system fails. It falls apart. And you may say to me, or your colleagues on the panel may say to me, well, what about waiver? And I would say there's certain things you simply cannot waive. The constitutional provision, Article 18, Section 5, the Rule 26B5, and the Statute 122506B all speak in mandatory language about what the jury is supposed to be doing. And there's no way to get around that. And I understand that the trial court and the parties did not grapple with this issue. I don't think they really understood the issue that confronted them.
Well, I think it goes beyond that, Mr. Abney. I mean, the way it looks to me like the parties explicitly agreed how they would try this case, and that involved comparing the fault of the decedent to the alleged fault of the defendants, and the fault of the decedent encompassing either intentionally taking her own life or misusing medications and taking medications she hadn't advised the defendants about. I mean, when I look at the joint pretrial statement, the parties explicitly agreed that whether Ms. Lane's actions directly and proximately caused her own death, and the approximate allocation of fault, if any, as agreed upon issues of fact and law. And I know you want, in light of that, you want to argue that this is fundamental error, but this is not simply a case where an objection was missed to a question or to an exhibit that was offered. This is the parties explicitly sat down and agreed how the case would be tried. So if you could comment on that, I'd appreciate it.
Yes, they agreed wrongly. They agreed in ignorance and by disregarding Arizona law. And if they had thought it through, they would have realized that what they were doing was a fundamental error. That you cannot allocate fault to a non-party without actually designating somebody as being a non-party. And especially in the suicide case, you run into a fundamental contradiction with with a mixture, of course, of intervening superseding cause. You deal with a fundamental problem that our Constitution, our rules, and our statutes are set up in such a way that the jury has to allocate the fault to all parties and properly designated non-parties. And if you don't have a properly designated non-party, you step into another problem, which is the burden of proof. When you've designated someone as being a non-party at fault, you bear the proof of proving that they had some degree of fault. It's on you, and the jury instructions and everything else that goes to the jury has to take that into account, that you, as a designator of a non-party at fault, which is what Frankie Lane is a non-party at fault, then you have to prove by preponderance of the evidence to the jury. And nothing was structured in that way that they had the proof. They could simply throw out there as a possibility that this overdose was intentional.
Mr. Abney, I don't mean to monopolize the questioning here, but I have to disagree with you respectfully. The jury instructions clearly state that the defense had the burden of proving that Ms. Lane was at fault, if at all. And I can't help but circle back to the original question, which was, in light of this record, and I'll note that neither party submitted the trial transcript to us. We have very selected excerpts of expert witness testimony, and that's about it. But on this record, you're really asking us to speculate as to how the jury looked at this case and reached its verdict. And I'm not sure that's our role.
Well, I'm not asking you to speculate on that. What I'm asking you to speculate on is the legal principles involved, the constitutional principles, statutory and procedural, and on whether this is such a fundamental right that there can be a waiver. I think it's unintentional that they just didn't grapple with what they were confronting, and therefore it resulted in what would normally be a waiver of the right to say, well, hold on, the jury has the constitutional duty to apportion and allocate fault. And
well, I'm going to piggyback on what Judge Winthrop asked, because even if we jumped through all of the procedural hurdles and we were addressing fundamental error, a core concept of fundamental error is prejudice. We have to find that there was prejudice. And given the lack of what we have as far as a record and what was stipulated to by the parties in their pretrial statement, how could we find prejudice on this record?
Well, you can find prejudice because under the comparative fault system, there has to be a clear approach to the case throughout that you have a non-party at fault, which you didn't have. So when she gets, and you do have the jury verdict form and the instructions and whatnot, and she's right there on the jury verdict form as someone you can apportion fault to. But how can you do that when she's never been designated as a non-party at fault? It's impossible under the system of comparative fault that we have and the procedural and statutory rules you have to follow. She could not be designated as a non-party at fault. That is a fundamental.
Well, I understand that, Mr. Abney, but we always equate prejudice to what was presented at the trial. And we don't have the record that was presented at the trial, do we?
You have the part of the record that matters, which is the
jury instruction.
You have the jury instructions, you have the pretrial materials, the pretrial statements and whatnot. You have the jury verdict form, and you have the result at the end. And you add all those things together, you have her being designated as a non-party at fault when she cannot be designated as a you have her on the jury verdict form when she cannot be there unless she's been properly and timely designated as a non-party at fault. They went right by that. The 150-day rule passed. There's no designation of her as a non-party at fault. She can't be on the verdict form. If she's not on the verdict form, then it's a yes or no choice on the defendants. She doesn't come into the equation at all because she's not there. And she should not be there because she was never properly designated as non-party at fault. That is a fundamental error, and it changes everything. Because the jury, instead of being confronted with a verdict form where they say, okay, we have the defendants and we have Frankie Lane, who do we decide at fault here? Or do we just throw up our hands and walk away from all this because we can't really parse through this because having her there confuses everything. But having her there is the error. She can't be on the jury verdict form because she's a non-party at fault who's never been designated as a non-party at fault. Which, of course, and you have all these issues that are jumbled together in a sense because then you go back to the suicide rule, which I don't think the Supreme Court has squarely adopted. It's come awfully close, but I don't think they have ever squarely adopted it. The Court of Appeals, I believe, is the one that accepted that as a principle. And of course, it's one of those common law rules that sounds great. If somebody commits suicide, then they're at fault, we're done. But there's so much more than that, especially in a case like this. This is not the traditional exits from the suicide rule are not here. This is more like the situation where you know somebody has suicidal ideation, they're in your care, and you know they're in the dumps, and it's a dangerous time for them, and you say, well, here's a loaded gun. Why don't you go do some target practice? That'll ease your mind. And they kill themselves because you facilitated the suicide. And you should at least be a little bit at fault for giving a loaded gun to somebody under those circumstances. And here, where she is being treated with some very powerful medications, the allegations are they gave her too much, they weren't supervising her enough, they weren't handling her care properly. And as a result of that, she unintentionally took too much medication and died. In a situation like that, if she were considering suicide, you've handed her the means to do it. And if she's not considering suicide, then you've helped her poison her own system by accident. In either event, the jury needs to decide these things, but it needs to decide them in the context of, okay, who can we hold at fault? And as you know, you all know from your experience as lawyers and in the judicial system, that juries, oddly enough, rely on the jury instructions and rely on the verdict forms. You know, we theorize about that and we talk about it as an aspirational goal, but they actually do rely on those things. And they're trying to work through complex, difficult cases like this. And what the jury had in front of it is they had the push the Frankie Lane button and we're done. And we just say, well, she's at fault 100%. We don't need to worry about anything else. Let's go home. And that's not the way this is supposed to work. But the big issue here is, in a sense, and as Judge Winthrop touched upon, and you've touched upon in a sense, is, and it's in the background, is can you waive these things? Are these things of lower importance sufficient that you can waive them? And that's an important principle. And if this court, I hope this court would say you can't waive it and we've come to victory. But if not, if this court could at least provide some guidance, because to me as a practitioner and to other lawyers, it looks like there's some things in this area you simply cannot waive. And the right to have somebody designated as a non-party at fault, the interaction of the suicide rule with intervening superseding cause, I don't believe that these kinds of issues are ones that can be waived. But if they're waivable, I hope this court will provide guidance to all of us in Arizona, whether they can be waived or not. And that's my basic presentation. If I have any time left, I'd like to reserve it. As always, I'm ready to answer any questions, or at least try to answer them.
Judge Winthrop, Judge Bailey, any additional questions at this time for Mr. Abney?
Not at this time, thanks.
All right. Travis, how much time does Mr. Abney have remaining? Travis?
Sorry, 4 minutes, 46 seconds.
All right, thank you. Ms. Freeman, you may begin.
Thank you. May it please the court, my name is Allison Freeman. I represent the appellees, defendants in this case, the Center for Orthopedic and Research Excellence, Inc., doing business as the Core Institute, and Dr. Joshua Abrams. I'd like to start by addressing the jury instruction regarding intervening superseding cause. First, the instruction properly informed the jury that suicide is an intervening superseding cause that breaks the chain of causation. And we've cited a case to this court from the Supreme Court that states that that's the law in Arizona. And that's Maricopa County versus Cohort, where the court said suicide by the injured party is a superseding cause which is neither foreseeable nor a normal incident of the risk created, and therefore relieves the original actor from liability for death resulting from the suicide. The court then added to the instruction, gave back to the jury the issue of some exceptions that would apply where the suicide would not be an intervening superseding cause. And those were whether the defendant's negligence brought about the delirium or insanity of Miss Lane that prevented her from realizing the nature of her act and the certainty or risk of harm involved therein, or made it impossible for Miss Lane to resist an impulse caused by her delirium or insanity, which deprived her of her capacity to govern her conduct in accordance with reason. Again, that was also from an Arizona Court of Appeals case, which is Tucson Rapid Transit Company versus Tochi, where they discussed those exceptions. And so here, that was the instruction given. The jury remained the finder of fact regarding 1, whether Frankie Lane committed suicide, and 2, whether the defendant's negligence brought about the delirium of Miss Lane that prevented her from realizing the nature of her act. The only issue decided by the court was that suicide, absent one of these enumerated exceptions, breaks the chain of causation. And in this way, the court was operating in a gatekeeping role on the issue of causation. She was setting the limits of causation, which our courts have recognized as appropriate for the judge to do. We cited the case of Patterson versus Thunder Pass, Inc. It's a dram shop case, but in there, the Court of Appeals, this court, applied the intervening superseding cause doctrine to a situation where the person had been overserved at an establishment. They prevented her from driving home. The establishment employees took her home, left her there, and then she proceeded to return to the establishment, get in her car, and cause a head-on collision. And the court said, exercising that gatekeeping role on causation, the court said that that was unforeseeable and extraordinary, and therefore a superseding intervening event. And that, again, is something that this court has just recently, as this past September, after our answering brief was filed, again applied the same doctrine in a case called Torres versus JAI Dining Services, 250 Arizona 147. So we know that the doctrine of intervening superseding clause is alive and well, and it is within the court's ability as the gatekeeper to say that some action or some event is being cut off from the chain of proximate cause, and that's what the court did here, and it was appropriate. And the other important aspect of that is the court's decision on what was going to be an intervening superseding cause here was not objected to. The plaintiffs did not argue about the terms of the instruction or that the exceptions enumerated were not right for the situation. And so the court exercised its gatekeeping role. There was no objection to how it did so. And that was within the court's right to do so. Now, the only objection that's been asserted for this court to consider is the question of, does the Uniform Contribution Among Tortfeasors Act or the Arizona Constitution prevent the court from providing that instruction on intervening superseding cause? And so what we've briefed to this court is that the doctrines are very different. Intervening superseding cause speaks to proximate causation. The jury has to find proximate causation before it can allocate fault. The allocation of fault process is something that happens later, and here the jury did get to perform all of those functions. It got to make the determination of whether there was comparative fault or whether assumption of the risk applied here. They are separate and distinct processes. So if we look at the Arizona Constitution, Article 18, it says the defense of contributory negligence or of assumption of risk shall in all cases whatsoever be a question of fact and shall at all times be left to the jury. And that's what ARS 12-505 says as well. And we know that there's separate and distinct issues, proximate cause and superseding cause, and this allocation of contributory negligence, assumption of risk analysis. We know this because there's a case, Watts v. Medicus, 239 Arizona 19, 2016 case that tells us this, that specifically explain the difference between fault and allocation of fault and a finding of causation, that they're different steps of the analysis. And we know this from looking at the case law in Arizona, from looking at cases like Patterson, where the court has the ability to say there's no causation in this case. For the court to say there's no causation in this case, that's not a breach of the Arizona Constitution, Article 18, Section 5. That's not a violation of ARS 12-505. It's an appropriate gatekeeping function, and that's what happened here. The issue of comparative fault, allocation of fault, was left to the jury. The jury was free to find there was no suicide. They were free to find one of the exceptions to the instructions on suicide applied. And they were free to find causation, breach, and comparative negligence or no comparative negligence. The instruction was appropriate and it was consistent with Arizona law. So moving on. Yes.
Sorry to interrupt, but I want to ask you about Mr. Abney's arguments about this whole non-party at fault issue. My recollection of the purpose of the non-party at fault statute is to give the parties early notice that someone who's technically not a defendant in the case or a party to the case acted in such a way that their fault should be presented to and considered by the jury, and that notice is given early enough that any opposing party can take steps to deal with it. So my question is, first is, was the issue of Ms. Lane's conduct, whether it's suicide or simply failure to follow medical instructions, was that notice provided early in the answer, in the initial disclosure statement, and the subsequent disclosure statements? Can you comment on that? And Mr. Abney's argument that not designating Ms. Lane specifically as a non-party at fault somehow reaches the level of fundamental error.
Yes, and I will address that also by reference to the record, because there are a couple things that answer that question that you may not be able to find in our briefing. So index of record 20 is the defendant's answer in this case. And on page 4, paragraph 24, it states defendants allege that all or a portion of plaintiff's injuries and damages, if any, were caused or contributed to by the actions or inactions of Frankie Lane. So right from the beginning, the assertion of negligence on the part of Frankie was disclosed. And then if we look to the Arizona case law about a wrongful death claim, we see in Aranda v. Cardenas, 215 Arizona 210, that wrongful death claimants are subject to the defenses that the defendant would have raised against the deceased. And then we have Gibson v. Boyle that says that includes contributory negligence or comparative fault. Now, one part of ARS 12505 that I don't think was properly put before this court is subsection B of that statute. And so when we're looking at that statute, we know that the issue of contributory negligence has to go to the jury. And then it says, if the jury applies either defense, the claimant's action, meaning contributory negligence or assumption of the risk, the claimant's action is not barred, but the full damages shall be reduced in proportion to the relative degrees of the claimant's fault, which is approximate cause of the injury or death, if any. And then subsection B of 12505 defines claimant's fault. It says in this section, claimant's fault, in quotes, includes the fault imputed or attributed to a claimant by operation of law, if any. So here we see that the section specifically provides for this situation. One, it addresses an issue where there's comparative negligence as a result of death. We know that's only something that could be brought in a wrongful death claim. And then it tells us if we have law like we do in Arizona, that the contributory negligence of the decedent is imputed to the claimant in a wrongful death action, it specifically says that is claimant's fault. And as a result, it is appropriate to assert contributory negligence against the wrongful death claimants based on the contributory negligence of the decedent. And the way that's done is the form of verdict that was given to the jury in this case, where it has a line for Miss Lane. The form of verdict was not objected to. The parties agreed to that form of verdict in this case. And so there was no need to name Miss Lane as a non-party at fault because the rules provide that instead the comparative negligence defense is the appropriate measure. So as a result, we cannot have fundamental error on that issue. Moving on briefly to unless there's any questions about the jury instruction or the verdict form, I will speak just briefly to the issue of the expert testimony. The full expert testimony of Dr. Markin and Dr. Simonian is within the court's record in this case. Dr. Markin was a pathologist. He testified to cause of death. Dr. Simonian was a pharmacologist, and he testified about a number of things, and it included opioid tolerance, drug interactions, toxicity, therapeutic doses, lethal doses, how those doses vary depending on the person, different makeup of different opioids, different effects and uses when prescribing morphine, fentanyl, oxycodone, other kinds of opioid drugs. He was educating the jury about very complex subjects, about why one dose of one opioid is different or the same as a different opioid. And there was a lot of testimony given to educate the jury. Dr. Simonian never testified regarding what caused Miss Lane's death. It is not in the record anywhere that he testified on that ultimate issue, and it was an appropriate separation of the issues. And we've cited case law on page 18 of our brief that explains that it is appropriate to have two different experts in two different areas of specialty speak to an issue where there is something different that they're providing. The rule actually provides that where an issue cuts across several professional disciplines, the court should be liberal in allowing expansion of the limitation upon experts established in the rule. And the testimony was not cumulative and certainly was not prejudicial. Unless there's any questions on any of those issues, that's all I have for you.
Judge Winthrop, Judge Bailey, any additional questions?
No, thank you.
No, thank you.
All right, thank you, counsel. Mr. Abney, any final word?
Oh, I've got a few. I hope they're somewhat useful. First of all, I'd like to remark on Patterson, which always seems to come up in any argument with Judge Winthrop is involved. It's a wonderful opinion. However, my thesis in my brief has always been that intervening superseding cause is, if you take it in its absolute pure form, is the kind of defense that is utterly incompatible with comparative fault principles, because you say, boom, we identify one person, one event as the intervening superseding cause, and we can ignore every other causative factor that has something to do with the result. And that's just not how pure comparative fault works. It's antithetical to it. I would note on the suicide rule, I did some intensive research in an amicus brief I did last year at the state Supreme Court about the amicus rule, which they dodged, I think. But at that time, there were 132 opinions that had mentioned in which the Arizona Supreme Court it mentioned suicide in any way, shape, or form. And my conclusion and my argument to the court is the Arizona Supreme Court has never actually adopted the suicide rule. It came close in the Cowart case, C-O-W-A-R-T, back in 1970, when it mentioned the common law suicide rule, but it decided the case under a standard of care analysis. And in 1985, it mentioned it again in the DiMontini case, but simply in a statement that is a general kind of rule, but it failed to adopt the suicide rule. This court gets the credit or the blame for adopting the suicide rule in Tucson Rapid Transit Company versus Tochi, which back in 1966, your colleagues at Division II adopted it. I believe it was Division II. And the Arizona Court of Appeals has repeated it since then, but it's not something that the state Supreme Court has adopted. And if you decide that it is not something that it's wise to follow, you do not have to follow it. That is up to you. As far as assigning some blame to the claimants in a wrongful death case, that's good, but it operates within the comparative fault procedural rules and statutory rules, which require designation of a non-party at fault. And if you don't have a non-party at fault designated, you don't get to put the non-party at fault on the jury form, which certainly focuses the attention of the jury on who is supposed to be where fault came. The final thing I note that my colleague said, as far as the expert issue rule, quote, full expert testimony is within the court's record in this case, end quote. And it is. What you need to do as far as resolving the expert witness problems and issues is in the record. What happened was that the expert, the pharmacologist, decided to give, with some prodding from the defense counsel, decided to give causation experts opinions about the death, that this was not just from fentanyl, which was what the basis of his testimony was supposed to be, but this was in the nature of an intentional overdose, which is simply a polite way of saying you committed suicide. I urge the court, if nothing else happens here of benefit to my client, at least for the benefit of all of us across the state, if you could discuss in your decision or opinion whether you can waive some of these fundamental rights. Specifically the notice of non-party at fault and designating people on jury forms as persons against whom the jury can allocate fault when they're not properly designated as non-party and they're not a party. And I think that sums up my presentation. I want to thank the court for your time and attention.
All right. Judge Winthrop, Judge Bailey, any additional questions from Mr. Abney?
Thank you,
Just-
Mr. Abney.
Just one question, Mr. Abney, going again to the non-party at fault issue. And you may not know the answer, and I'll just drill down into the record, see if I can figure it out. But in these types of cases, medical malpractice cases, the rules provide for a mandatory pretrial conference early on in the case where there are a number of issues discussed with counsel. And counsel are expected to report to the court on the status of these issues. One of which, if I recall, is the status of any non-parties at fault. Do you know whether the record reflects whether that issue was in fact presented to the court at that early stage of the litigation and discussed?
If that's a question mark there, I'm ready to answer.
Yes.
And the answer is no. As far as I know, there was no discussion about that. There should have been, and that's a lapse on the part of everybody involved, not just the plaintiff's lawyers, but the defense lawyers and the court itself. It's just, you look at this, you come to this fresh, as I usually do on appeal, and you look at the record and you go, oh my gosh, why in the world wasn't this non-party at fault issue dealt with in a proper way? And I don't have an answer for that, but it wasn't. And I believe under the circumstances, because of the fundamental nature of the non-party at fault system to trying to get justice in tort cases, that there has been no waiver. This is a fundamental legal issues are at stake in this matter.
So just to be clear, your sense is the record shows that issue was not raised or discussed.
I believe that is correct, Your Honor.
All right, thank you.
Thank you.
All right. Thank you, counsel, for your presentation and your briefing in this matter. The matter is deemed at issue and a decision will issue in due course. Thank you.
Thank you, Your Honor.
Thank you.